know it's early. But what better way to start your day than by getting free legal advice? This is Vastola on the Law with your host, attorney Jeff Vastola, featuring 30 minutes of free legal advice. Call in now with your questions. 877-850-8585. That's 877-850-8585. Now here's your host, attorney Jeff Vastola.
Well, good morning, everybody, and thank you so much for tuning into Vastola on the Law. I am Jeff Vastola, your host. I'm here live almost every weekend on Saturdays at 7:30 to give you free legal advice. I do sincerely apologize to anybody that might want to watch this via Facebook Live because, once again, I'm having technical difficulty. My son has taken the iPad to a sleepover, and so I'm trying to use my laptop. And it is not working. So unfortunately, there will be no Facebook Live this morning until I can get this figured out. But I do have 30 minutes of free legal advice for all of those listening on the radio show. And of course, this show is meant to be 30 minutes of free legal advice. And that doesn't necessarily mean that it's 30 minutes of me talking to you about a topic that I have planned. Of course, that will happen if I don't get phone calls. But my preference is to answer your questions. So if you have a question and you would like some free legal advice, please call into the show. And the number to do that is 877-850-8585. That will get you live on the air with me. Sharina will take your phone call. She will talk to me quickly and we'll put you live on the air. If I can answer your question right here and right now, then that's exactly what I'm going to do because that's the purpose of the program. If I cannot answer your question because I am not a jack of all legal trades, I do not know a lot about a lot of different areas of law. I only know about, off the top of my head, I should say, those areas that I practice day in and day out, which, by the way, are personal injury, wrongful death, product liability claims, medical malpractice, those types of things. If you ask me a question and I don't know the answer, then I will do the research that I have to do to get back with you the following week with an educated answer to your question. And this typically become my topic of the day for the following show because the research oftentimes becomes very interesting, and so does the answer, at least in my opinion. This month is National Impaired Driving Prevention Month. December has been tagged, I suppose, by President Obama as the month to focus on impaired driving and what we can do to try to prevent it, at an absolute minimum to try to minimize it. And there's all kinds of articles on this, as you can imagine, all kinds of websites. But what's shocking to me, and it's kind of sad, are the statistics. And what you see are that, first of all, over 30 million Americans are driving drunk in a given year. 10 million Americans are driving impaired by illicit drugs in a given year. But statistically, the greater percentage of those people that are driving drunk or using illicit drugs are 16 to 25 years old. And I guess it kind of makes sense when you think about it because these are younger drivers that really don't have a lot of experience drinking alcohol or perhaps, using medications or drugs that they're not supposed to be using. And they just don't realize, unfortunately, how those things do impair a driver. So that's why the statistics are not surprising to me that this demographic of driver, the younger drivers, are causing more of the accidents because there are a lot of fatalities involved in these. I think these 30 million driving drunk episodes are statistics where people are injured or killed. So what do we have to do to eradicate that statistic so that our younger populations are no longer driving drunk or driving once taken illicit drugs? I know what I've done with my daughter. I'm going to continue to do it. As a personal injury lawyer, I've seen these consequences way too often, way too many times. And I talked to her about it. I talked to her about the realities of the loss of life. I talked to her about the realities of the consequences of the drunk driver and how young people can go to prison for a very long time. So if you have young drivers in your household, if you have family members and perhaps other households that are young drivers, just remind them December, National Impaired Driving Prevention Month, obviously trying to prevent catastrophic accidents, and hopefully we can get those numbers down significantly just with a little education. I think that would be a good idea. I'm still talking about maybe putting on a seminar in the early part of next year. Of course, COVID came along and interfered with my plans to start doing seminars in 2020, but hopefully in 2021 we'll be able to do that. And I think as perhaps part of my seminars, there will be kind of a presentation or a chapter, if you will, on young drivers and how to make them safer for everybody. If you'd like to find out more about me, your host, my name is Jeff Vastola. I am an attorney, and I do practice full-time. I have an office in Stewart. I have an office in Palm Beach Gardens. But essentially, I represent clients throughout the state of Florida for anything that they may require in the field of personal injury, wrongful death, or products liability, or medical malpractice, those types of things. If you feel as though you have something to talk to me about because you have questions, you think you may have a case, or because you're looking to hire an attorney in any of those areas and you feel like I may be the man for the job, then call me personally. The number to do that is 833-VASTOLA, 833-827-8652. Vastola being my last name, V as in Victor, A-S-T-O-L-A. And you will reach me on my cell phone. That toll-free number is forwarded to my cell phone 24/7. And if I don't answer, leave me a message and I will call you back as soon as I can. If you have questions for me that are of a radio show nature, but you're calling my cell phone or you're calling my office during the week, please don't be offended if I ask you to call the show. It's been happening with more and more frequency, and because I do prefer people to call into the radio show, just because it makes the show a lot more interesting, to be honest with you, when people call in, I have been emphasizing that to say, if you call me about an issue, about a landlord-tenant, or about a family law, or something else, I will certainly try to help you with some kind of an immediate response to say, perhaps call this person, especially if it's an emergency. But I do want you to call the show because it's helpful to others that may be listening. They might learn from your predicament, whatever it may be. They might learn from the advice that you get. It might be helpful. And at the end of the day, the show becomes much more interesting than just hearing me talk for 28 minutes or so. So please, for those of you that know, continue to pray for my dad, if you wouldn't mind. My dad is still fighting COVID. He's in a sedative-induced, I guess you call it a coma. I was talking to a doctor yesterday, and I'm not quite sure if I was using the right terminology, but he is unconscious on a ventilator and has been for way too long. So if you would continue to pray for my dad, we would certainly appreciate that. So thank you very much. I have on tap today some case law discussions, case law updates. I like to talk about these cases that I see in the Florida Law Weekly that I get. It's a publication that I get on a weekly basis. And sometimes the cases are informative, but oftentimes the cases are very interesting. And so that's why I like to go through these things. And I apologize, my phone is chiming in the background. All right, so let's just kind of dive into some cases. My topic of the day was the National Impaired Driving Impaired Prevention topic. If anybody has any questions about that, let me know, because I've got several web pages and statistics and everything else. But let's just all do our best to prevent young drivers from driving under the influence over the next few weeks, especially while they're out of school, having parties, things of that nature, and hopefully we can cut down on those accidents. But if you've ever been interested to find out what it would take to get a stalking injunction, then I've got the case for you. This is out of the 4th DCA, which is here locally. The 4th District Court of Appeal governs counties of Broward, Palm Beach, Okeechobee, Martin, St. Lucie, and Indian River counties. So pretty broad area, but it's within if you're listening to the show, you're very likely within the audience of the 4th DCA. This is a case of Joseph Cash versus Patrick Gagnon. It's out of the Fort Lauderdale area, Broward County. And it's a stalking case where two individuals living in the same apartment or condominium complex just could not get along, and it was becoming very acrimonious between the two of them. But the trial court issued the injunction saying, I feel there's enough here, there's enough evidence, there were enough altercations, nothing ever physical, but apparently a lot of yelling and cursing and everything else. So the trial court said, I'm going to go ahead and issue the injunction because I believe there's enough here. The fourth DCA, sitting in the appellate capacity, said, no, we don't believe as though there's enough, so they reversed the injunction. A stalking injunction is something that would prevent somebody from being within a certain number of feet of the other person and preventing the person from having any communication or contact with the other person. An injunction is something that can, the way it's written, depends on how it's written, it can force somebody not to do something, as I just explained, not to come within a certain distance or not to have contact. An injunction can also be written to force somebody to do something that they're not doing, but they're supposed to do. So injunctive relief is a remedy that you can request in the courthouse, depending on what your cause of action may be. But it can be affirmative injunctions, and it can also be, I guess, what would be considered a negative injunction, where you're not supposed to do something. But when it comes to stalking, there is a statute. The statute, and I'm looking in the opinion to try to find it, but it says under section 784.048, subsection 2. So that's if anybody's interested in finding the stalking statute, it's Florida statute 784.048. It says, to qualify as stalking under the statute, the conduct must meet two requirements. First, the defendant's conduct must cause substantial emotional distress, which is greater than just ordinary feeling of distress. And they use the reasonable person standard, not a subjective standard. So they're not taking that person's case specifically. They're saying, okay, would a reasonable person, some hypothetical reasonable person standing in the shoes of that person, have these emotional distress damages? And that's why this case was reversed, because ultimately the appellate court said that we don't feel as though the plaintiff who was seeking the injunction, applying the reasonable person standard, really suffered enough emotional distress to cause an injunction to be issued. It says mere irritation, annoyance, embarrassment, exasperation, aggravation, and frustration. It's an and, not or. All of those things, without more, does not equate to substantial emotional distress, which is kind of a surprising thing to say, because they list irritation, annoyance, embarrassment, exasperation, aggravation, and frustration. That's 6 different categories of emotional distress, and they say without more, that's not enough. I think, frankly, with injunctions, you've got to have, first of all, physical violence would be an automatic contender, but you've got to have perhaps threats. You've got to have something that rises much more to an aggressive level. I guess that's what the court is saying. And then secondly, the second prong of the test is that the course of conduct must serve no legitimate purpose. So courts have generally held that contact is legitimate when there is a reason for the contact other than to harass the victim. Now, this particular case dealt with 2 individuals living in the same community, and both were on the board of directors at certain times, and oftentimes they were arguing about neighborhood issues. So perhaps the court took into consideration that sometimes these abusive experiences were actually a difference of opinion with regard to how things were being done in regulating the community. So I guess that's another reason. So the next case that I wanted to talk about, and this is a very tragic case in and of itself, because it's a wrongful death case, but it's even, in a sense, more tragic locally because of a story that came out about a week ago, I guess. And I only learned of it on Thursday when a friend of mine told me about it, because I prefer not to watch the news and I didn't know about it. but one of our own, and I say that because I live in Tequesta. There's a Tequesta local, very young woman about to get married. Was just an absolutely bizarre situation. Was sitting in a chair at the beach watching her husband play ultimate frisbee down in Singer Island, Riviera Beach, when a stray bullet struck her, and she ultimately died when her parents had to take her off of life support. So my condolences to the family, absolutely, without question, just an absolute tragic situation. But the reason why this case I'm going to talk about reminds me of that situation, which I only heard about 2 days ago, is because of just how eerily similar they are. So this is the case of Pride of St. Lucie Lodge 1189, which does business as Temple 853. It's one of these social lodges up in St. Lucie County, versus Tierra Nicole Reed as the personal representative of the estate of Tanya Renee Oliver. Now, the way this case is styled, it would sound like the lodge is suing the individuals, but it's actually just the reverse. The personal representative, which is the daughter of the woman that was killed, filed a lawsuit against the Pride of St. Lucie Lodge. They went to trial and they won. And so the lodge filed this appeal, which now shows up in this Florida Law Weekly. And it is a 4th District District Court of Appeal case because, of course, it comes out of St. Lucie County, which is within the district. And what's interesting about this case is that the appellate court upheld the jury verdict. So the plaintiffs, unless the Florida Supreme Court picks this up, which I don't know if it ever will, have prevailed. They've won. And what they did was they sued the lodge for negligent security because a brawl broke out inside the lodge during a social event. And then, as everybody was told to leave, a second brawl broke out in the parking lot. And then after the second brawl, the security guards came out and were trying to disperse everybody, or apparently not doing it very well, or not doing it according to protocol. And members of one group came back with a gun and fired shots into a car, and one of the bullets hit this woman who was killed, whose name is Tanya Renee Oliver. The case went up on appeal because the lodge argued to the appellate court that it had requested a jury instruction that the trial court refused to give. And specifically, that jury instruction was one emanating from Florida Statute 768.075, which says that a person or organization owning or controlling an interest in real property shall not be held liable for the negligence that results in the death to a person who is attempting to commit a felony or who is engaged in the commission of a felony on the property. Well, factually, what we know about this case from the evidence that was presented to the jury is that the woman that was killed, the woman that was shot, participated in the brawl inside of the lodge, and very regrettably, for one reason or another, we just don't know, struck a pregnant woman who was, I guess, part of the other party. So that was part of the brawl. And so because striking a pregnant woman, well, striking anybody is a crime. There's no doubt about that. But striking a pregnant woman is an elevated crime. It carries a more significant penalty. And so the lodge said, well, because this second brawl occurred in the parking lot because the decedent, the person that died, punched the pregnant woman, and then while she was sitting in the car in an effort to retaliate, I suppose, shots were fired and she was killed. The lodge said we should have been given a jury instruction that because this woman was engaged in a felony, she, or the lodge, is not responsible for negligence, utilizing the language of Florida Statute 768.075. Well, the trial court disagreed and said there is a time at which the crime is no longer happening. And the appellate court, the 4th DCA, affirmed the trial court's decision because the trial court said, no, I'm not going to give that jury instruction to the jury because by the time the lady was shot, so much time had transpired that she was no longer engaged in a felony. She was no longer beating on a pregnant woman. She had struck her once. It was several minutes prior to the shooting. And so she was no longer engaged in the crime. And so therefore that jury instruction was not applicable. It was not given to the jury. So the jury never even heard that instruction. And the jury rendered a verdict on behalf of the plaintiff, the personal representative being the daughter of the woman that died. So very interesting case factually, very tragically and very eerily similar to the case that happened on Singer Island, where a woman was minding her own business. Well, not to suggest that the lady watching Ultimate Frisbee did anything wrong. My understanding is she was just watching her husband play a game when she was struck by a stray bullet. So clearly there was no suggestion that she was doing anything. But very tragic. Very tragic things do happen in this world, and oftentimes we're shielded from it because it doesn't happen to us. But that was the case of, let me get the name, Pride of St. Lucie Lodge versus Tierra Nicole Reed as the personal representative of her mother, who was Tanya Renee Oliver. Very tragic. Another case I wanted to talk about, not to talk about the merits of the case, but only because it was very, very strange. There's a case of ESJ J1 Operations versus Todd Domek in my November 13 Florida Law Weekly. I'm trying to get caught up here. And it was talking about an award of attorney's fees that were predicated on 2 rejected proposals for settlement. And it's a very short opinion, and it's really not anything I was planning to talk about. But proposals for settlement, that might be a topic for discussion in the future. But as I moved on to my November 20th Florida Law Weekly, I started reading through it, go through it case by case by case, and all of a sudden I saw the same case name, ESJ J1 Operations LLC versus Todd Domek. And I immediately thought to myself, wait a minute, I just read about that case, and it has nothing to do with this, because now in this one, a week later, the appellate court is talking about how the trial court properly entered summary judgment for the counter-defendant on a counterclaim alleging fraud, which has absolutely nothing to do with the opinion from the week before. And again, I'm not going to talk about either one of these cases on the merits. All I wanted to do was say how incredibly odd it is, because I've never seen a situation like this where the appellate court, and let me see what DCA this is. I didn't even think to look. I think it's third. Yep, it's the third DCA out of Miami-Dade County. How it issued 2 different appellate decisions in 2 successive weeks on different issues in the exact same case. I've never seen that in all the years that I've been a lawyer. Typically, appellate decisions are going to encompass all of the issues of that one case in one opinion. So that's really the only reason I brought it up, because it was strange to me, not because there's really much interesting about the opinions, in my opinion. The last case I want to talk about, and this is a case that is very interesting to me, and it maybe be interesting to you as well. And remember, I've been talking for a long time. You might be able to get a question in if you want. 877-850-8585. That's the number to call into the radio show. And I apologize because I've gone for quite a while without giving the number, but I probably have time for one question if you want to call in. 877-850-8585. While I'm waiting for that phone call, I'm going to talk about the case of Brandon Bailey versus State of Florida. And anytime you hear a case that's styled that way, you can know that's a criminal case, because the state of Florida prosecutes crimes. So this is interesting. This defendant, Brandon Bailey, was ultimately arrested and prosecuted for first-degree murder, armed robbery, and possession of a firearm. But that's not so much what the case is about. What I find interesting about this case is how the state's prosecution team ultimately got the judgment from the jury and how they linked the pieces together. If you haven't heard the term before, there is something that prosecution, and even really any kind of a lawyer can use it, depending on what kind of a case it is. But nowadays, with all of the cell phone usage and all of the smart cars and things that are in cars that you may not even be aware of, you leave behind what they call the electronic footprint. And what's interesting is criminals oftentimes have no idea just how easy it is to track them with their electronic footprints. And this is a case where using the cell site location information, which is essentially these cell phone towers that that gather information from either cell phones or GPS devices or whatever, they were able to track the movements of this defendant, Mr. Bailey, and ultimately tag him to the crime. But what happened was, you would never think that this would work. He borrowed a friend's car, and that car was enabled with a GPS device. And the prosecution was smart enough to figure that out. And they were able to use the GPS locations from this guy driving around in his friend's borrowed car to link him to the crime. And the analysis is really very interesting because it goes into the United States Constitution issues. Thank you, Shrina. Specifically the Fourth Amendment, which protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. So the analysis goes into a lot of different cases, specifically the case of Carpenter, the case of Jones. But ultimately, this appellate court says that this was not the utilization of the GPS device on a borrowed car to ultimately prosecute a criminal was not a search. It did not constitute a search, and therefore his guilty verdict was upheld. Thank you so much for listening to this version of Vastola on the Law. I'm Jeff Vastola. If you want to talk to me about a case, dial 833-VASTOLA. That's 833-827-8652. Thank you for the continued prayers for my dad. Have a great week. Bye-bye.